Sponsor license and authorizing officers. Authorizing officers have the level 1 access to the sponsor management system. They get a password, user ID and password. They are not allowed to share that password with anyone. However, we have seen where employers are doing things themselves. They don't have legal representatives. They have a habit of sharing these passwords to another employee or whoever is someone else who is dealing with the sponsor management system, because anyways the AO is the senior person. But home office does not like this, and because of that home office usually would suspend a license. And these are cases where that situations where they have suspended, and there are ways to reinstate the license as well. So we have done cases similarly where license has been revoked for some inconsistency in behavior, sharing of password for example, and other things also will come into. If so, it's not necessary, I don't advise people sharing passwords, but yes, if this has happened, there is a new data policy. So the new data protection policy can be put in place in the company, and any such mistakes can be undone, and home office can be requested to reinstate the license. In the past, home office has accepted where it has been reasonable, but if there is a too much abuse of the system, yes, they are not going to reinstate it, they are going to completely revoke the license. But yes, if it is a genuine mistake, many times authorizing officers don't take it very seriously. They may share the passwords and all. That is one thing that can be undone, but it is on a very case by case basis what has happened, how compliant are the employers on other factors, whatever are the other compliance requirements that they are required to meet for the sponsor license. If everything is fine, just password sharing, it has been undone in the past. We've also dealt with represented sponsors and requested home office that it was a genuine mistake, given all the evidence, asked the employer to put in the data protection policy, and in future it will not be done again. So that is one thing, and home office has most of the time agreed with such situations, unless there are other concerns also. If they have many concerns, they are not going to reinstate, they are definitely going to revoke. But then this is one of the common things, common mistakes that we are aware of as lawyers. It does happen, home office is aware of this. So it's a very case specific situation. If you have any such situation where license has been suspended or anything like that has happened, compliance action has been taken, please do seek immigration advice. You can book a paid consultation with us. We do provide advice. We don't provide any free advice. Another second option is sometimes employers pay the employee in cash. I don't know why, but yes, it has happened where we advise the employer and they have started paying them in with a bank transfer, and then given the evidence to home office and explained everything to the home office, and home office has reinstated any compliance actions that they decided to take. So it is possible to reinstate a suspended sponsor license, or any compliance actions can be undone if it was a genuine mistake, employer is not aware of it, there was no bad intention. The intention is where everything comes to, remember that, especially in immigration rules or anything for that matter in life. Intentions is what even the caseworkers will focus. Even as a lawyer, I would focus on the intentions. If I'm having consultation, I need to understand all the facts, saying what was the intention, was it by mistake, was it genuine, so, or was it done intentionally to avoid something, or refrain from doing something. So in that case, paid in cash, this is another example. So these are just some of the examples where reinstatements are possible. Home office has accepted in the past explanations, evidences showing this was a genuine mistake. Cash salaries changed into bank transfers, and henceforth we will be meeting this policy. Asking for forgiveness, reinstatement has been possible, but the reinstatement very much depends on the facts of the case. How much violations are there, how many are there, what is the extent of the violation, was it complete disregard of the law, or was it just a genuine mistake? So many factors come into play. Any compliance action that has been taken on the sponsor license, on the employer, it can be mitigated in a way if it was genuine, and to a certain extent. For your specific situation, if you are stuck in a situation where anything that you foresee is going to happen or has already happened, do book a paid consultation with us. We can discuss, we can advise you what is possible, what is not, and you take it from there. We can also represent you, or you can just take advice and go on from there. So just wanted to touch on these points, because many times employers think that okay, I made this mistake, that's the end of the game. So it's not the end of the world. If it's a genuine mistake, it can be explained, evidence can be produced, things can be sorted out, and the circumstances can be mitigated. Whatever were the mitigating circumstances, whatever reasons you had for doing such a thing, either sharing a passport or password or paying in cash or whatever that is, it has to be explained. It's not necessary that every time Home Office is going to agree to that, but yes, if it is a reasonable mistake and a genuine mistake, usually Home Office would be reasonable on those fronts. Thank you very much.